So more family court rules. There's 4-week sessions of court and there's 13 terms in a year. For the purpose of this part, the word judge shall include a support magistrate where appropriate. Proceedings shall be assigned to a judge upon the filing with the court of the first document in the case. So similar to civil, where the party filing first paper pays the index number fee, this is an assignment to a judge upon the filing of the first document in the case. The judge shall be known as the assigned judge. Okay, so this is a repeat question. List reasons why a judge may consider to exclude general public from courtroom. It's a study question. And again, this is disruption, objected to, compelling reason, orderly and sound administration of justice, protection for the children or litigants, and less restrictive alternatives unavailable. And thanks, Dorothy, for making that quiz. Family Court Rules 205.7. The prefix for commitment of guardianship and custody is B. The way that I remember this is commitment of guardianship and custody means termination of parental rights, and B stands for bad parents. 205.7. The prefix for approval of foster care placement is L. I remember this because approval ends with the letter L. 205.5. Subject to the provisions of CPLR 8002, who shall be permitted access to the transcribed minutes of a proceeding in family court? And the answer is A, the petitioner, presentment agency, and adult respondent in the family court proceeding and their attorneys. B, when a child is either a party to or the custody of such child may be affected by the proceeding, the parent or parents, or PLR, and their attorneys, the guardian ad litem, an attorney for that child. And remember, a guardian ad litem is not the same thing as an attorney for the child. An attorney for the child is obligated to fight for the wishes of that child, whereas a guardian ad litem is only looking for the child's best interests. So it's different. 3, an authorized representative of the CPS involved in the proceeding or the probation service. So the probation service is permitted access. 4, an agency to which custody has been granted by family court order and its attorney. So the agency's attorney. So 5, an authorized employee or volunteer of a court-appointed special advocate program appointed by family court to assist in the child's case. And then judicial conduct if like the judge isn't under investigation. Going back to the question, the answer is A. The other two both have something wrong with them. It's not the adult respondent, it's the child. And other courts can only get a copy of certified pleadings and orders, not transcribed minutes, without court order pursuant to this section. So that's why the answer is just A. 205.4. Any person may be excluded from a courtroom only if the court determines on a case-by-case basis that exclusion is warranted in that case. Using your knowledge of the family court rules, list the factors the judge may consider in exercising this inherent and statutory discretion. The person is causing or is likely to cause disruption in the proceedings. 2, the presence is objected for a compelling reason. 3, the orderly and sound administration of justice, including privacy interests, the need for protection, particular children from harm requires that somebody be excluded. And 4, less restrictive alternatives are not available or they're inappropriate. Whenever the judge exercises discretion to exclude any person or the general public from a proceeding, the judge shall make findings prior to ordering exclusion. Nothing in the section shall limit the responsibility and authority of the fucking chief administrator or the administrative judge with the approval of the fucking chief administrator to formulate and effectuate reasonable rules and procedures consistent with the section as may be necessary and proper to ensure the access, the safety of persons, yada, yada. Okay, so going back to the question, you should have listed those 4 things, which is basically disruption, compelling reason and objection, administration of justice, and less restrictive alternatives unavailable. Those should have been the 4 that you got. Within 60 days of the filing of the petition and documents required for an agency adoption, the court shall schedule a review of said petition to determine if there is adequate basis for approval. If such basis is found, the court shall schedule the appearance for approval within 30 days of the date of the review. Rule 205.59, and there is a separate video on this. Just be aware that the 30 days is calculated from the date of the review, and the adopted parents and the child actually have to appear before the court. Rule 205.24, an ACD and a JD proceeding may include which of the following terms? Answer you should have got was 1, 2, and 4, but not 3 because the amount is $1,500. 205.24, a copy of the order of ACD shall be furnished to, and then there's a list here, and you should have gotten 2 and 3, but not 1 or 4 because it's furnished to the respondent and the parent or the PLR. It's not furnished to the complainant or victim or the presentment agency. Now, take note that this is different in the criminal law. So in CPL, when there is an ACD, there is no requirement that the defendant be given a copy of the terms and conditions. This is only specific to family court juvenile delinquency proceedings and probably in some other articles in family court, but is not required in the CPL. 205.26 was a fill in the blanks. Now this is something that you should have memorized because it is such a gift question if they give it to you because it's such a tiny rule. So 205.26 says when a child who is the subject of a JD proceeding absconds from a facility, written notice of that fact shall be given within 48 hours by an authorized representative of the facility to the clerk of the family court, so the clerk of the court from which the remand was made, upon receipt of the notice of the proceeding shall be placed on the calendar no later than the next court day, and the court shall give notice of such date to who? To the presentment agency and appointed or retained counsel for the child.